Good morning. May it please the court. My name is Jamie Wallace, and I represent the appellant, who's Mr. Lawrence Eggle and was the husband in this case. This is an appeal in respect solely to the amount of alimony. I want to first just review specifically the factual findings that were made by the trial judge in this case. As to the wife, and this is found on pages 4, 5, and 6 of the final judgment, the trial court judge found that she was a licensed mental health counselor. She held a master's degree in rehab counseling. She had worked for 19 years in Sarasota at the Child Protection Center and for Coastal Recovery. Goes on in the final judgment to say other things that she had done. And it says in the past she'd earned as much as $100,000 a year after earning her master's degree. She was currently working part-time at the time of the trial in this case, which was August of 2012. The wife brought in a vocational expert, and her own expert testified that she was only working 27 to 28 hours a week. The reason for that was she had been caring for her elderly mother, but at the time of trial that had just stopped. So Dr. Rothard, the expert, testifies that the wife could immediately obtain employment in the geographical area in which she was located and could earn from between $54,000 and $57,000 a year plus benefits, and Dr. Rothard said those benefits would equal approximately 25% of her salary. She then said, Dr. Rothard, and the judge notes that the same expert further testified that the wife was qualified for unemployment in jobs where she could earn between $60,000 to $75,000 a year. When the trial judge then goes through the husband's qualifications and what he's doing, the judge notes he was an engineer. He'd held various jobs as an employee since moving to Florida in 1996, where he has earned between $40,000 and $60,000 a year.
For a moment, you mentioned many times throughout your brief that the former, what we refer to as the former husband's earnings were between $40,000 and $60,000 over a 10-year stretch from 1996 to 2006. Where did the higher numbers come into play? In other words, there's also your opponent comes back and says that's just not right. There were years when he earned $100,000. As a matter of fact, in 2011, I think he earned about 80-some thousand, but then
right.
lost a client or something.
That's correct. That's correct.
You are steadfast that his earnings are between 40 and 60, and your opponent says no, they're not. So help me out. Who's right?
Well, the judge, he mentioned 75 at one point, and that was in the interview. The judge obviously did not find that to be credible. The judge never included it anywhere in his factual findings. But
was it the former wife's expert who put into the record that his earnings were as much as $100,000 in some of those?
No.
Where did that come from?
I don't think it's ever said $100,000. It said $100,000 in respect to the wife. The most the husband had made, and it is true that he made $84,000 the year of the divorce. The divorce was filed in August of 2011, right. and that was the most he'd ever earned. And that's what the expert said. That's what the husband said.
Well, actually, both parties were higher earners before the marriage, earning amounts around $100,000. But then, for some reason, after the marriage, the income of both dropped. And even the expert, first she says she had a difficult time following his income stream when it was outside the 40 to 60 range. And so she quantifies at least 1 year he makes 82.
Right, 82 or 84, and that was the year of the marriage. And the point that I was trying to make in my brief is that there really wasn't that history in the marriage. The history in the marriage was 40 to 60.
And that was the same year that the petition was filed.
That's correct.
82.
That's correct, in 2011. Now, after the judge goes through, and he does say on page 6 he says 82,000 in 2011, he then goes through the sort of sordid history about the husband being arrested, both parties filing domestic violence injunctions against each other, the fact that the husband never was convicted, the state null process those. But as a result of that, he lost this client that had provided, he said, 60% of the revenue in the year that he had done so well. So he was only making $48,000 a year at the time of trial. What's interesting is when the judge makes his conclusions then in paragraph 30 of the final judgment, he says the wife has a need for support for a limited period of time. Doesn't tell us really why, just says a limited period of time. Both the husband and the wife have the present ability to earn more than they presently are earning, as set forth in their most recent financial affidavit. The testimony of the vocational expert, which the court accepts, established the husband's capable of earning at least $72,000 annually, and the wife up to $45,000 annually if she makes an effort to expand her practice and collect fees. She can earn up to $54,000 a year if she makes an effort to learn minimal computer skills. Now the judge makes one of the most interesting statements. While the wife is not imputing income, it does find that the wife is voluntarily underemployed. It goes on then to talk a little bit about the criminal filings and that, and the domestic violence injunctions. And then it says the wife has established a need for alimony in the amount of $2,000 per month, which will be for a duration of 7 years. The judge in no way goes through what any of the expenses are. What she claimed on her affidavit was in excess of like $7,500. He never says how he gets to the $2,000.
Counsel, let me go to one of your points on appeal. With the exception of addressing the standard of living specifically in the finding, does the trial court not address all of the other factors under 61?
No, I think
he talks about their employment. He doesn't talk. He talks about their education. I believe implicitly there may be a reference to their health, but he fails to specifically talk about their standard of living.
Yes.
But is there evidence in the record, for example, from the expert as to what their standard of living, and would that not suffice in terms of permitting us to perform a full appellate review?
Well, yeah, I think I'm not sure what you're asking. You mean in terms of the need? I mean,
evidence in the record from which the finding could be established, is that not adequate? And especially when he fails to mention only one specific area under 61.08, and that is, what was the party's standard of living?
Well, I think you could look at the financial affidavits, obviously, and get some indication from that, and the recitation of the final judgment about the value of their house. In this case, I mean, I think the amount of alimony is limited really by ability to pay. Because when I went in and argued the motion for rehearing, which the trial judge granted, I said, listen, you found the wife was making $45,000, he was making $72,000, you give her $2,000 a month, that ends up with her at $69,000 and him at $48,000, and you give no basis for that, and that's in essence making him go to misfortune, her to prosperity when you look at these two compared to each other. The judge then also accepted my argument, which is $45,000, judge, wasn't testified by anybody. It was really $4,500 is what she said, and that would be $54,000 a year. So when he does enter his order after the rehearing, for the first time he says he's imputing, and he says he's imputing to the wife and $54,000 and imputes $72,000 to the husband. Now, I think there's a big distinction there about the imputation, because again, he looks at what he says the husband is capable of earning, and my argument is that the standard for imputing income to the husband was not followed, because what the judge did was accept Dr. Rothard's testimony that this was the state's median wage data for an engineer in the state of Florida. And all of the cases...
Did Dr. Rothard not also say that there are adjustments made in the table that he relies upon for the greater Sarasota area?
Well, I don't recall that. It was clearly the state's median wage area earning or
with
data.
Adjustment for your particular locality.
Okay.
In fact, he specifically, at one point, segregates out Tampa, Venice, Sarasota.
She. Mm-hmm.
She.
Yeah. But the case law says that you have to look at recent work history, occupational qualifications, prevailing earnings in that community right there. And I do not believe that the judge looked at that at all, just accepted that medium wage thing. Thing is, with this particular husband, he had never earned that, and the judge didn't do the same thing with the wife. With the wife, the judge looked at what the expert said she could immediately make. This is what she could do immediately, not what the average would be for psychologists in Sarasota County or the state of Florida. And I argue that that's, it's not fair in this instance. It would be like taking a lawyer and saying, it doesn't matter that you practiced 15 years and you averaged X. I'm going to take the state's median data or wage for lawyers, whether it's Sarasota County or the state. And my argument is essentially that with these two, there were no children. Husband's 58 at the time of trial, wife's 59. The real findings or the real conclusions of the vocational expert as to what they had historically made and were making then were so close to each other that why was the alimony awarded. But more importantly, let's look at what the judge did on the rehearing. The
judge essentially cut the amount in half and doubled the time frame, right?
Exactly. I mean, yeah, and I argue, Judge, it's not even $1,000 a month if you take the 54 and even if you leave it at the 72.
What the judge was trying to just sort of get them both on equal footing using the numbers that the judge came up with.
I believe so in doing 1,000, although that gives her a little more, even using his numbers.
And a little more
for the wife, right.
No children, comparable earnings history, education, whatnot.
Right. But no justification for doubling the time, except that obviously the wife's counsel, even though they had not asked for a rehearing on the term of the alimony, said, oh, well, if you're going to do that, you're going to half the amount you're going to give her, you need to double the time, and that's exactly what the judge did, although he went over the 14 years. Yeah.
And your argument is that there should be none at all, right?
I think there should be none at all, number one, but the default to that is even if you're going to accept that the 1,000 is appropriate, which gives her a little more, what was the justification for the extreme length of time? There was nothing, he makes his own statement that it's a short period of time that she needs the alimony, and he doesn't on rehearing tell us why now suddenly it's supposed to be 15 years, which is clearly a violation of the statute. Thank you.
Thank you.
If it please the court, my name is Larry Chulak. I represent the appellee, Ms. Susan Krinsk. She's unable to be here with me today because of the illness of her mother, and she's the only local family that mother has. As I listened to the argument, and as I read through counsel's brief, I wanted to point out to the court, and I was struck by a few things that I believe were not intentionally, but perhaps misrepresented or misstated, what the applicable standard of review is and what the actual testimony was that the judge heard. One of the things I was struck by is you read through the appellant's brief is nowhere do they mention what the applicable standard of review is. The standard of review for imputing income is competent and substantial evidence. The standard of review for alimony is abuse of discretion. One of the things that the court did go back and rectify in its amendment to the final judgment was he imputed income to both parties. He went back and instead of comparing apples to oranges, he compared apples to apples. The testimony of the wife's vocational expert was clear on a number of things. One, during her interview of the husband, she found him to be evasive, not forthright. He seemed to have a problem remembering the larger amounts he made, but he sure had a good memory of the smaller amounts. However, she mentions, and I'm looking at page 131 of the trial transcript, that he did acknowledge having made $75,000 a year, and when she asked him, did you ever make $100,000 a year, she couldn't get a straight answer. She testified that my client was in fact capable of earning somewhere between $54,000 and $57,000 a year if she was to collect all of her receivables or she was to go to work for someone else, but she had that capability.
Counsel, let me interrupt you a second.
I'm sorry.
Going back to your comment about competent substantial evidence, the trial court specifically finds that the wife is voluntarily underemployed.
Yes.
The trial court does not make a finding before imputing income to the husband. Where is the competent substantial evidence on that point?
Your Honor, the trial court also found that the husband was voluntarily unemployed.
At what point in the amended final judgment?
He finds that both are capable of earning more than they are making. In the court imputed income to both parties.
Correct.
In the final judgment,
But income was not imputed to the husband until the amended final judgment.
I apologize, Your Honor. I'm hearing impaired and I couldn't hear you. I'm sorry.
Income was imputed to the husband only in the amended final judgment. And in that amended final judgment, he does not talk about the husband voluntarily being unemployed, but he does address the wife's voluntary unemployment.
In the, I believe in the final judgment, the court points to the fact that both parties were earning less than they were capable of earning. In particular, the court listened to and took note of the fact that during the course of his interview by our vocational expert, the husband acknowledged that he was doing absolutely nothing to go out and find new business. He was in a holding pattern, if you will, until the case was over. Our accountant testified that, and one of the things that has been left out here is one of the things that our accountant brought out at the trial is that he was working for two companies while the case was being tried. He had his own company, Evoke Technology, and then he was also working for another company called Mustang, which he stated he was working for Mustang so that he could get, they put him down as an employee, he got a salary from them, and he therefore got insurance benefits. Our accountant testified that in 2011, which was the year this case was initiated, the husband's total gross income was $84,000. Also listened to testimony that he was doing nothing in the way of attempting to expunge his mugshot from the internet, and basically he was in a holding pattern until the case is over. The judge listened to this. Another thing that the court seems to be left out is the court is also entitled to take into consideration in determining an alimony award the total financial status of both parties. During the course of the case, the testimony, which was unrefuted, was that the husband ended up with non-marital assets being distributed to him in excess of $100,000 more than those which were distributed to the wife. The husband at the time of the trial had a 401k with a balance of $141,000 in it. Wife had nothing. In terms of whether or not, and I don't know if the argument was made, but it is made in their brief that perhaps the judge was searching to come out with the same amount in toto, as the words that are used, when he amended the judgment. But if the court were to do the math at the 7-year rate, which he originally put in his judgment, the total alimony, 7 years, $2,000 a month, $164,000. In the amendment to the judgment, 15 years, $1,000 a month, that's $180,000. It appears, and we have suggested, that it would be disingenuous for us to say that the award in the amendment to the judgment did not exceed what he was entitled to award under the statute, the alimony statute, because durational alimony could not exceed the duration of the marriage. The marriage here was a little over 14 years and 9 months. He awarded alimony for 15 years. However, when the court looks at his amendment to the judgment, I believe the court can infer that, if you call it misremembering, or maybe he didn't write it down correctly, but he thought 15 years was the length of the marriage. He specifies that in his amendment to the final judgment. He determined the durational alimony will be paid over a period of 15 years, comma, the length of the marriage. So Judge Gilner did not know that or feel that he was going over or beyond what he was entitled to do. It's a couple other points that I will bring up. And if I could ask, how much more time do I have, Your Honor?
About, you have about 8 more minutes.
8 minutes? Mm-hmm. Thank you, Your Honor. We also cited in our brief that a court can impute income. We cited, I believe it was the Valentine case. If the court finds that somebody is not using their best efforts to earn a living, and the testimony of Dr. Rothard was replete with acknowledgments by the husband that he was going out of his way not to earn as much as he could. She testified, she offered to help him find another job, and his response was, I don't want another job, just find me more clients. Also, when Dr. Rothard was questioned about what my client could make and acknowledged that she could make up to $57,000, and she was then questioned further on if she went to work for a company, could she expect a benefit package? And Dr. Rothard stated yes, and in this day and age you add about 25% onto that. However, in that same and during that same testimony, she says, however, you would have to add that same 25% benefit package on to what Mr. Eggle could earn. And she testified that Mr. Eggle could earn as much as $91,000 plus a benefit package, but that if he was, in all likelihood, worst scenario, go to work for another company and start at the bottom, he would be at about $72,000. Again, you have to add the benefit package to that. A couple last things I will point out in the appellant's brief. On page 5, and as I think the court has already established and found, over and over again in the brief, it's mentioned that husband during the course of the marriage earned between $40,000 and $60,000 when he acknowledged to Dr. Rothard that that wasn't the case. He earned as much, at least that he could remember, as much as $75,000. In the final judgment, and page 10 of the appellant's brief, top of page 10, both the husband and wife have the present ability to earn more than they presently are earning as set forth in their most recent financial affidavit. I'm quoting from appellant's brief. She cited page 410 of the record. Now, when you say that both parties have the present ability to earn more than they presently are earning, that seems to me is another way of saying they're both voluntarily underemployed, or at least they're both underemployed. Very quickly. And again, page 14 of the appellant's brief, up at the top, the report and the evidence in this case only supports the finding that the husband's prior work history showed earnings between $35,000 and $60,000. Totally not true. I cited to the testimony of Dr. Rothard, where she testified that he acknowledged he had earned as much, at least, as $75,000. When you take a step back from this case, you have on one side a husband who is capable of earning somewhere in excess of $75,000 if you include benefits. You have a wife who is capable of earning somewhere around 54 to 57 plus benefits. You have one party who is going to end up with $100,000 more in non-marital assets and who has $141,000 in his non-marital 401k. Wife has nothing for her retirement. Next argument that was made by counsel in the brief was this was improper because by doing it for 15 years, you're going to bump up against his retirement age. Well, if that was the case, then we could never have permanent periodic alimony because at some point that would always bump up against somebody's retirement age. And as we pointed out, at such time as he truly retired, he always retained the right to file a supplemental petition and reduce his alimony under 61.14. So that isn't and shouldn't be looked at as an issue. We don't believe that the court abused its discretion. We believe that the court chose not to take this evidence that he heard like tunnel vision. He took everything in and made what he considered to be a fair award. We believe that the proper remedy here, because of the fact that he extended the alimony about 2 months beyond the duration of the marriage, is to remand the matter back to the trial court with instructions to amend Instead of $1,000 a month for 15 years, it should be $1,000 a month for 14 years and 9 months, thereby not exceeding the duration of the marriage. Thank you.
Thank you.